So Shivesh, I will send it your way. Yeah.
Wow, Dylan, that was quite an introduction, I must say.
I was, we worked on it all night.
Oh, you worked on it all night. Okay. All right. Well, thank you very much, Dylan, for that introduction, and good morning to everybody. Thank you so much for joining myself, Shivesh Sewpal at HR CoLab, but also Dylan at WorkWeek for this webinar this morning. As I mentioned to you, I'm Shivesh Sewpal from HR CoLab, and today we are going to unpack a topic that is highly relevant to the construction and project-based environment, namely how to manage casual, fixed-term, and contracted labor in a way that is both operationally practical and legally compliant. The focus of today's session is specifically on South African construction sites and project environments, where employers often need flexibility, but where that flexibility can very quickly create legal risk if worker relationships are not structured correctly. So today's webinar is really about helping employers, managers, and decision makers understand when someone is truly an independent contractor, when a casual worker is still legally an employee, how fixed-term contracts should be used properly, what the risks are with labor brokers, and what practical compliance steps you can take immediately to protect the business. Before we begin, just one important note. This session is intended actually as a practical legal compliance guide based on South African labor legislation as of June 2026. It is not a substitute for case-specific legal advice because every workplace and every fact pattern is different. Let me quickly take you through what we'll cover. Today's webinar is structured through 8 key areas: why this matters now, the compliance landscape, and why construction is such a high-risk sector, employee and independent contractor, because classification is the foundation of everything else, casual workers on site, what rights they still have and where employers usually go wrong, fixed-term contracts, especially the 3-month rule under Section 198B of the Labor Relations Act, labor brokers or temporary employment services, and the concept of joint liability, bargaining council compliance, particularly the BCCEI, 2026 legislative developments, what is already law and what is still only proposed, and finally, a practical compliance toolkit that you can take back to your business and start applying almost immediately. My aim is to keep this practical and grounded in real site-based scenarios, not just legal theory. Let's start with the bigger picture, why this issue matters so much right now. Construction is one of the sectors where the distinction between employee, casual worker, contractor, and labor broker worker is tested the hardest. And the reason for that is simple. Construction businesses often operate with project-based labor needs, changing site demands, multiple subcontracting layers, and tight commercial pressures. That naturally creates a reliance on non-permanent labor. If we look at the labor market context, South Africa's national unemployment rate sat at 31.4% in Q4 of 2025. Youth unemployment was around 57%. Construction added roughly 35,000 jobs quarter on quarter into Q4 2025, making it one of the strongest performing sectors at the time. And importantly, around 1 in 3 workers nationally are working informally or in informal arrangements without the benefit of proper employment protections. Why do these statistics matter? Because they explain why the law leans so heavily toward protecting vulnerable workers where the facts are unclear. In other words, if the paperwork is weak, the records are poor, and the relationship looks like employment in substance, the legal system is often going to favor the worker, not the label on the contract. So the key message here is this. In construction, flexibility is often commercially necessary, but it has to be structured properly documented properly, and managed properly. There are 4 reasons I see construction as one of the highest risk sectors from a compliance perspective. First, project-based work. Construction businesses often genuinely need short-term labor, project labor, replacement labor, and flexible labor. That is lawful. The problem is that this same commercial reality also creates the temptation to mislabel workers to avoid statutory obligations. Second, multiple layers on one site. You may have the principal contractor, subcontractors, labor brokers, independent specialists, and casual laborers, all operating on the same site at the same time. Every layer increases the chance of non-compliance and makes accountability harder to track. Third, overlapping regulation. This sector is not governed by one single source. You're dealing with the Labor Relations Act, the Basic Conditions of Employment Act, the National Minimum Wage Act, occupational health and safety obligations, and potentially bargaining council rules such as the BCCEI. Fourth, burden of proof. And this is the practical sting in the tail. If there is a dispute about status, wages, hours, or compliance, the employer is usually the party expected to prove what happened. So if the question is who worked, for how long, under what terms, at what rate, under whose supervision, the employer needs to have the records to answer that. That is why this webinar is not just about legal definitions. It's about paperwork, systems, and proof. Now we move on to what is really the conceptual heart of this webinar. How do we determine whether someone is truly an employee or an independent contractor? Because almost every other compliance issue flows from getting this classification right. The key point here is that South African labor law does not simply accept the label the parties choose to use. You can call someone a subcontractor, a consultant, a casual, a freelancer, or an independent contractor, but the CCMA and the Labor Court will still ask, what is the real relationship in practice? The main legal sources that guide this analysis include the Constitution, the Labor Relations Act, the Basic Conditions of Employment Act, the Employment Equity Act, and importantly, the Code of Good Practice. Who is an employee? So the golden rule here is the contract label is not decisive. The actual working relationship is what matters. If the contract says independent contractor, but everything about the relationship looks and functions like employment, the label won't save the employer. This is one of the most important slides in this presentation. Section 200A of the Labor Relations Act creates a presumption of employment for workers who earn below the BCEA earnings threshold. The current threshold as at 1 May 2026 is 269,600 Rand and 90 cents per annum. If any one of the listed factors is present, the worker is presumed to be an employee, and the burden then shifts to the employer to prove otherwise. Let me say that again, because it is critical. The presence of any one factor is enough to trigger the presumption. The 7 factors are: the manner of work is controlled or directed by another person. The worker's hours are controlled or directed by another person. The person forms part of the organization. The person works an average of 40 hours or more per month over the preceding 3 months. The person is economically dependent on that one client or employer. The tools or work equipment are supplied by that person or employer. And the person works for only one person or one business. For a construction audience, that means if you have someone on site who reports at a time you set, use your tools, wears your PPE, works under your foreman, and works only for you, you are already in a very dangerous zone if you're trying to treat that person as a pure independent contractor. This is the misconception I most want attendees to leave today having corrected. A lot of managers assume that all 7 factors must be present before a worker is presumed to be an employee. That is incorrect. The legal position is the opposite. 1 factor is enough to trigger the presumption. And this matters because once the presumption is triggered, the employer has to prove why the worker is not in fact an employee. That is much more difficult exercise than that many businesses appreciate. So if there's one line for your supervisors, site managers, and foremen should remember from today, it is this: 1 factor is enough, not all 7. Now, what happens if the worker earns above the earnings threshold, or if the employer tries to rebut the Section 200A presumption? Then we move into what is commonly called the dominant impression test. This means the court or the CCMA looks at the overall relationship and asks, who really controls the work? Whether the person is integrated into the business, whether they are economically dependent, and whether they carry the risk and reward of running an independent business. A useful construction example is the one on the slide. Imagine a bricklayer who is supplied with tools and PPE by the contractor, is told what time to arrive on site, works only for that contractor for several months, and performs core building work that sits at the heart of the contractor's business. Even if the paperwork says subcontractor or independent contractor, that arrangement is very likely to be viewed as employment in substance. So the question is not, what does the contract call this person? The real question is, what does this relationship actually look like day to day on site? That is the question the CCMA will ask. Let's move from the contractor versus employee distinction into the next common category: casual workers on site. One of the most important messages in this webinar is that casual is not a legal escape hatch. In South African law, casual work may describe the pattern of work, for example, intermittent or short-term engagement, but it does not strip the worker of basic labor rights if they are still legally an employee. So what does casual status not change? First, minimum wage still applies. A casual worker, day laborer, or part-time worker is still entitled to at least the national minimum wage for every ordinary hour worked. There is no casual exemption from the minimum wage. Secondly,
mind if we have a question from Marion.
yes.
You mind just giving it a quick answer? So, please advise what definition defines a contractor as opposed to an employee.
All right, give me 1 second. I'm just going to the chat.
Q&A.
There we go. As I mentioned, I'm also new to Zoho webinar, so please bear with me. Please advise what definition defines a contractor as opposed to an employee. Okay, now that's perfect. Thank you very much, Marion, for that great question. If you don't mind, can I ask Dylan, perhaps we can maybe answer the questions towards the end, because some of the next slides may actually answer these questions.
Yeah, perfect. Great.
Would that be great?
Yeah, 100%.
Marion as well?
Thumbs up.
Perfect. Please let me know if you can still see the presentation.
Yeah, we still got it. It's great.
Fantastic. So, second, casual workers can still be employees. If they work for another person for remuneration and they are not genuinely independent contractors, they can still fall squarely within the definition of employee. Third, leave and UIF still matters. Leave accrues on a pro rata basis. and UIF contributions are still due once the employee works more than 24 hours per month for the same employer. Fourth, records are everything. In practice, the biggest issue with casual labor is not usually the idea of casual work itself. The real problem is that employers often have poor or no records of who worked, when they worked, how many hours they worked, what they were paid, and under whose supervision they worked. This is where the risk sits. In the construction environment, there are a few recurring failure points. Hiring from labor queues or at the gate. People are brought onto site for the day with no written terms, no induction record, no attendance register, and often no real payroll trail. Paying flat day rates. A worker might be paid a flat amount for the day that sounds commercially reasonable, but if you divide that amount by the actual hours worked and it falls below the national minimum wage, the employer has a compliance problem. Repeated re-engagement. This is a big one. If the same casual worker is called back day after day, week after week, or month after month, you may no longer be dealing with a truly casual once-off arrangement. That can start to look like an ongoing employment. No PPE induction or safety records. This is not just a labor issue, it's also an occupational health and safety issue. If a casual worker is injured on site and there is no evidence of induction, PPE issue, or safety training, the employer is exposed on multiple fronts. If I had to give construction employers one of the cheapest and most effective compliance fixes available, it will be this. Implement a daily or weekly time and attendance register for every casual and short-term worker signed by both the worker and the supervisor. Why is this so powerful? Because one simple document helps you prove who was on site, when they were there, how many hours they worked, who supervised them, and whether the amount paid was compliant with the hourly minimum wage. It also doubles as part of your health and safety evidence trail. So if attendees leave this webinar and implement nothing else immediately, this is one of the first controls I would recommend. Fixed-term contracts. Now let's move to fixed-term contracts, which are extremely common in construction because projects naturally have start and end dates. The problem is not using fixed-term contracts. The problem is using them incorrectly. Section 198B of the Labor Relations Act is the key provision here. The broad rule is that where Section 198B applies, a fixed-term contract may not exceed 3 months unless the employer has a justifiable reason for a longer fixed-term arrangement. There are a few important carve-outs and exclusions, but for today's purposes, the practical point is this. If you want to keep someone on a fixed-term contract beyond 3 months, you should not just rely on habit or convenience. You need a proper legal basis. Examples of justifiable reasons include a temporary increase in the volume of work, a genuine project of limited duration, replacing an employee who is temporarily absent, or a contract linked to a foreign national's work permit period. For construction employers, the most common justifiable reason is usually project-based work with a defined duration. So if a person is employed specifically for the structural phase of a project, a shutdown, a specialized installation, or a defined site package, that may well be justifiable, provided it is properly documented. This is where Section 198B becomes dangerous if not managed carefully. If the contract exceeds 3 months, Section 198B applies, and the employee cannot show a valid justifiable reason, then the employee may be deemed to be employed indefinitely. In other words, permanently, by operation of law. That means the end of the fixed-term contract is no longer just the natural expiry of a contract. It may be treated as a dismissal, which then has to be substantively and procedurally fair. There's also a second risk. Even where the fixed-term contract is lawful, repeated renewals or assurances can create a reasonable expectation of renewal under Section 186 1B. So if an employer repeatedly renews short-term contracts or tells the worker, "Don't worry, we'll keep extending," the worker may later argue that they reasonably expected renewal or ongoing employment. My practical recommendation is very simple. For every fixed-term contract over 3 months, write the specific justifiable reason directly into the contract. Not vague wording like "for operational reasons," but clear wording such as "this contract is concluded for the duration of the structural phase of Project X, expected to conclude on specific date in terms of Section 198(b)(4) of the Labor Relations Act." That wording won't solve everything, but it puts you in a far stronger position than a contract that is completely silent on the reason. The next category is labor brokers, or what the legislation calls temporary employment services, often abbreviated to TES. This is one of the most misunderstood areas in practice, especially on busy sites where labor is brought in through third parties. A TES arrangement creates a triangular relationship: the client or principal contractor, the labor broker/TES, and the worker. On paper, the labor broker may recruit the worker and process the payroll, but from a legal perspective, that does not mean the client is insulated from risk. Section 198A tells us that temporary service generally refers to work that does not exceed 3 months or is done as a substitute for a temporarily absent employee, or falls within a category defined as temporary by a bargaining council or legal instrument. If the work is not truly temporary in the sense, and the worker earns below the earnings threshold, the worker may be deemed to be the employee of the client. That is a major point. It means that if you are a principal contractor, keep TS workers on site beyond the temporary service window, and the work is not generally temporary, you may find that those workers are regarded as your employees for the purposes of the LRA. So what does this mean in practice for a principal contractor or client? First, you can become the deemed employer. If labor broker workers remain on site beyond the allowed temporary period on work that is not generally temporary, you may inherit the full labor law obligations in respect of them. Second, you remain exposed even if the broker runs payroll. This is because Section 198A creates joint and several liability in certain circumstances. That means if the labor broker underpays workers, breaches the BCEA, breaches the National Minimum Wage Act, or breaches the bargaining council agreement, the claim may still land on the client's desk. Third, forum matters. Disputes under Section 198A to 198C followed the dispute resolution route in Section 198D. And if the site falls within BCCEI scope, the matter may need to go to the BCCEI dispute structures, not the CCMA. A practical takeaway, and my practical advice, is that before engaging any labor broker, the principal contractor should insist on a proper broker compliance pack, including proof of UIF registration, proof of COIDA registration, proof of payroll compliance, bargaining council registration where relevant, and a service agreement containing indemnities and audit rights. Now, to be clear, an indemnity clause does not remove your statutory joint liability, but it does at least give you a contractual mechanism to recover loss and show that you took compliance seriously. Now let's turn to the bargaining council compliance. specifically the Bargaining Council for the Civil Engineering Industry, or BCCEI. This is an area where I think many employers underestimate their exposure. The first point to make very clearly is this. If the BCCEI collective agreement has been extended to non-parties, it can bind employers within scope, even if they are not members of the Bargaining Council. That is why saying we never joined the BCCEI is not necessarily a defense. Why does this matter? Because BCCEI compliance can affect wage rates, conditions of employment, dispute forums, and even tender eligibility. Many developers, principal contractors, and funders increasingly want to see a letter of good standing before awarding work. So the practical questions construction employers should ask themselves are, does our operations fall within BCCEI scope? Do we have the current gazetted work, wage, and task grade agreement? Is our letter of good standing current? If there is a dispute, are we routing it to the correct forum? This is not just an HR issue. It is also a commercial and tender risk issue. This slide is useful because it highlights another practical reality. The national minimum wage is not always the benchmark. In sectors covered by bargaining councils, the bargaining council rate may be higher than the national minimum wage, and where that happens, the higher rate generally becomes the relevant rate. So for example, the BCCEI published task grade rates for general workers, and other categories show hourly rates that are significantly above the national minimum wage. The practical message to attendees is, do not assume that if you are paying above the national minimum wage, you are automatically compliant. You may still be underpaying if a bargaining council rate applies to that role. That is why rate checking needs to happen against both the national minimum wage and the relevant sectoral or bargaining council rate where applicable. Let's now look at the 2026 developments. And I want to separate these into what is already law and what is still proposed. That distinction matters because one of the easiest mistakes in webinars like this is to accidentally treat a bill as if it is already binding law. There are two key figures attendees should leave with today. First, the national minimum wage. The national minimum wage increased to 30 Rand and 23 cents per hour from the 1st of March 2026. That applies to casual workers, day laborers, part-time workers, and ordinary employees for every ordinary hour worked. Second, the BCEA earnings threshold. The BCEA earnings threshold increased to 269,600 Rand and 90 cents per annum from 1st of May 2026. This threshold is very important because it affects who falls within certain BCEA protections around hours and overtime, and who benefits from the Section 200A presumption of employment. So if attendees take only 2 payroll compliance actions after today, they should be: check all pay rates against the current national minimum wage, and audit which employees sit above or below the BCEA threshold. Now let's talk about the Labor Law Amendment Bill 2026. As at June 2026, the bill is not yet enacted law. It is still moving through the legislative process. So my message to attendees is prepare for it, monitor it, but do not treat it as it is binding law yet. The proposals include things like strengthening the presumption of employment for gig and platform workers, introducing guaranteed hours or written hour protections for variable hours workers, expanded parental leave concepts, and changes to retrenchment rules. From a construction perspective, the proposal around guaranteed or variable hours is particularly relevant because it could affect how businesses structure casual and on-call labor in future. So the right message to your teams is the minimum wage and earnings threshold changes are law today. The amendment bill is still proposed. So start planning for it, but do not present it internally as if it is already compulsory. This slide is really about how to communicate the message internally. I would frame it as follows. The national minimum wage and basic conditions of Employment Act threshold changes are enforced now. Payroll and contracts must reflect them immediately. The Labor Law Amendment Bill is not yet law, but it gives us a good indication of where regulation is heading. So the right business response is to prepare our templates, offers, hour clauses, and workforce models now, rather than waiting for the legislation to catch us off guard. That way, management understands the difference between mandatory compliance today and future-proofing for tomorrow. Let's finish with the practical part of the webinar, the toolkit. Because ultimately, the value of the session is not just understanding the law, it's knowing what to do with it. This is the slide I would encourage attendees to either screenshot, print, or take back to the office. These are the 12 practical checks I would recommend. Run a classification audit. Look at every contractor and ask whether they truly are one, especially against the Section 200A factors. Audit payroll against the BCEA threshold. Identify who falls below the threshold and who sits above it. Rate check every role. Check every role against the national minimum wage and, where applicable, the BCCEI and other bargaining council rate. Confirm bargaining council status. Check whether your business falls under the BCCEI or any other relevant bargaining structure. Review all fixed-term contracts. If a contract runs beyond the 3 months, ask, what is the justifiable reason and is it recorded? Review labor broker arrangements. Confirm whether the work is truly temporary and whether your joint liability exposure looks like. Implement signed attendance registers. One of the simplest and most important controls for casual labor. Issue written terms to all non-permanent workers. Even if the engagement is short, document the hours, rate, duration, and reporting structure. Confirm UIF and COIDA coverage, especially where workers are crossing the 24 hours per month threshold. Align occupational health and safety records. Make sure site induction, PPE issue, and incident records all capture worker categories, not just permanent employees. Train site supervisors. This is crucial because many engagement decisions are made by supervisors and foremen, not HR. Calendar quarterly compliance reviews. Because the national minimum wage, the basic condition of employment threshold, and the bargaining council rates do not all move on the same cycle. If an employer worked systematically through those 12 points, they would already be in a significantly stronger compliance position. If I had to simplify compliance into one practical instruction, it would be this. Every worker should have a file, physical and/or digital, containing the core documents that tell the story of the employment relationship. That file should include a signed contract or written terms, time and attendance records, proof of compliant payment, UIF and COIDA confirmation where applicable, induction and PPE records, and where labor brokers involved, the compliance broker compliance pack and service agreement. Why does this matter? Because when a dispute arises, the business often wins or loses, not on what it meant to do, but on what it can prove. and the worker file is where that proof lives. Before we move into questions, let me briefly recap the figures and legal triggers that should remain front of mind. The national minimum wage is 30 Rand and 23 cents per hour. The basic conditions of employment earnings threshold is 269,690 cents per annum. Section 200A, the 7 factors, and any one can trigger the presumption of employment. Fixed term default cap under section 198B, 3 months, unless there is a justifiable reason. Temporary employment service, temporary service cap under section 198A, 3 months, unless a valid exception applies. If attendees leave today remembering only these numbers and concepts, they will already be far better equipped to identify risk. On this slide here, we've put together how WorkWeek and HR CoLab can help. As HR CoLab, we provide services in reviewing casual, contracted, and temporary labor arrangements to identify compliance risks. We do an assessment of worker classification, fixed-term contracts, and labor broker temporary labor arrangements. We facilitate drafting and updating of compliant contracts, policies, and supporting HR documentation, payroll, overtime leave, and record-keeping compliance checks for non-permanent workers. We facilitate the implementation of onboarding, engagement, renewal, and workforce management processes, as well as provide practical HR guidance to help businesses manage flexible labor in line with labor legislation. How WorkWeek can help you. WorkWeek provides shift management for casual, contracted, and temporary labor, improve visibility over who is working, where they are working, and the hours being worked. WorkWeek facilitates time and attendance tracking to support payroll accuracy and overtime monitoring. It's a centralized workforce records to reduce reliance on manual timesheets and fragmented admin, better oversight of labor utilization, shift allocation, and workforce deployment. And the system allows reporting insights to help managers monitor attendance trends, labor usage, and workforce capacity. With that, we are going to head now into questions. Very much to everybody that's been in attendance today. It's been a pleasure presenting to you. I once again apologize if I stuttered or, maybe slow down in certain areas. It's my very first time presenting a webinar, but, for us at HR CoLab, information and sharing of information is key. And that's why we wanted to do this, go on this adventure with WorkWeek. So please also do share some feedback. It helps us improve on what we could do better, what we've done well. It gives us a great insight if this webinar has been useful as well. So once again, thank you very much from HR CoLab. Please do reach out if you wish to get in contact and ask any questions, even for a consultation. You're more than welcome to.